Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the case of Pichra Warg, Kalyan Mahasabha Haryana Registered and Another versus State of Haryana and Another, wherein the Hon'ble Supreme Court discussed the concept of creamy layer in relation to Haryana Backward Classes, Reservation in Services and Admission in Educational Institutions Act 2016. But what is creamy layer? We have heard this term so often. In layman language, creamy layer could be termed as a sort of exclusion from the backward classes for the purposes of reservation on the basis of socio-economic factors such as income, social status, etc. A similar definition has also been provided under Section 5, Subsection 2 of the Haryana Reservation Act. Before adverting any further, let us also briefly peruse the texts of Article 14 and Article 16, Clause 4 of the Constitution of India. Article 14 states that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. And Article 16 Clause 4 provides power to the state to make provisions for reservation of posts in favor of backward classes that are not adequately represented. The brief backdrop of this case stems from the celebrated case of Indra Sahni versus Union of India, wherein the court directed the state governments to identify creamy layer amongst the backward classes and exclude them from the purview of reservation. In this regard, the Haryana Second Backward Classes Commission was constituted on 12th of October 1993. The state government accepted the recommendations of the commission and decided that the benefit of reservation shall not be extended to certain persons. Thereafter, in the year 2016, the Haryana Reservation Act was enacted, in which Section 5 provides that no person belonging to creamy layer amongst the backward classes shall be given reservation. In exercise of the powers conferred by the 2016 Act, the state government issued a notification on 17th of August 2016 specifying the criteria for exclusion of creamy layer within the backward classes. As per the said notification, children of persons having gross annual income up to Rs 3 lakhs shall first of all get the benefit of reservation in services and admission in educational institutions. The left out quota shall go to that class of backward classes of citizens who earn more than Rs 3 lakhs but up to Rs 6 lakhs per annum. The sections of backward classes earning above Rs 6 lakhs per annum shall be considered as creamy layer under Section 5 of the 2016 Act. Thus, two classes of persons, one having income up to Rs 3 lakhs and the other having income between Rs 3 lakhs and Rs 6 lakhs was created. Another notification dated 28th of August 2018 was also issued by the state government, indicating that gross annual income to be computed shall include income from all the sources. These notifications dated 17th of August 2016 and 28th of August 2018 were challenged before the court inter alia on the following grounds. 1. The subclassification of the backward classes is arbitrary and violative of Article 14 of the Constitution of India. 2. Such classification would result in depriving the benefit of reservation to persons belonging to backward classes who have income between Rs 3 lakhs to Rs 6 lakhs. 3. According to the Indra Sahni judgment, economic criterion cannot be the sole criterion for identifying the creamy layer. 4. The said notifications are violative of Section 5 of the 2016 Act, according to which social, economic and other factors are to be taken into account for specifying the criteria for exclusion and identification of persons belonging to the backward classes as creamy layer. 5. clubbing of salary income and agricultural income, and computing gross income by including income from all sources according to the notification dated 28th of August 2018 would result in exclusion of a large number of eligible sections of backward classes from seeking reservation in appointment to public services and admission to educational institutions. Now let us go through the pertinent observations by the court. Firstly, the court quoted the relevant excerpts from the Indra Sahni judgment, wherein it was observed that if some members of a backward class are advanced socially and economically, then it becomes imperative to exclude such persons from the ambit of reservation. The basis of exclusion of such advanced persons should not only be economic but also social, and imposition of any income limit must have correlation and significance with their social advancement. According to the court, Article 16, Clause 4 aims at group backwardness and not individual backwardness. Exclusion of individuals who are socially advanced members of a class ought to be excluded to further the object of Article 14 and Article 16, Clause 4. Secondly, the court opined that the notification dated 17th of August 2016 is in flagrant violation of the Indra Sahni judgment, as in spite of Section 5 subsection 2 of the 2016 Act, making it mandatory for identification and exclusion of creamy layer to be on the basis of social, economic and other relevant factors, the state of Haryana has sought to determine creamy layer from backward classes solely on the basis of economic criterion and has committed a grave error in doing so. Therefore, upon cumulative consideration of the matter, the Hon'ble Supreme Court struck down the notifications dated 17th of August 2016 and 28th of August 2018 and directed the state government to issue a fresh notification that is in compliance with Section 5 of the Haryana Reservation Act and the Indra Sahni judgment. That was all about the case. So what are my concluding remarks? Reservation is a tricky and a touchy issue. Emotions run high when people discuss the topic of reservation. But despite the diverse public opinion, our laws and judicial pronouncements do provide for existence of creamy layer in reservation, the rationale for which has already been explained in this judgment. In my humble opinion, reservation represents the complex socio-political and economic reality of our country. Our society is quite compartmentalized and divided in many senses. The law too acknowledges this. And in order to bring everyone at par, affirmative action in form of reservation has been introduced, and quite rightly so. Today, due to reservation, people belonging to backward classes are able to connect to mainstream life and enjoy good income and social status. The concept of creamy layer only furthers the cause of reservation, as it helps in identifying the neediest candidates who deserve the benefit of reservation. Hence, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us. If you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.